There we go. Actually, I'm just going to hold it. Welcome, everybody. My name is Melanie Hodges Neufeld, and I'm from the Law Society of Saskatchewan. On behalf of all the SALI partners, I'd like to welcome you all for attending our wonderful talk tonight. I'd also like to welcome those who are joining us on live stream. We invite you to join the conversation on Twitter at #SALI17. And if anyone on watching live stream has questions, they can email them in to createjustice@usask.ca, and we'll get those read out for you. Anyone in the audience tonight who has any questions, if you could just save them to the end, that'd be great. And I'll go around with the mic so that the recording and the live stream, people can hear you. We also invite you to enter your name for rider's tickets if you're here in person at the end of the talk. There's a ballot box right here beside Beth at the front. So I'll get to my introduction. So I'd like to introduce our keynote speaker. It's John Greacen, giving our talk tonight, Legal Information, Legal Advice, and Access to Justice, the distinction as it is understood in the United States. Welcome, John. I'll just give you a bit of his bio. John Greacen is currently a principal of Greeson Associates, LLC. He wrote the seminal article on the difference between legal information and legal advice for court staff in 1995, and continues to publish regularly on the topic. He was editor of the California Bench Book on Self-Represented Litigants and author of the Bench Book chapter on judicial ethics. He has made educational presentations on dealing with self-represented litigants in many states and in Canada. Mr. Greacen received the National Association for Court Management Award of Merit in 1999. He is project consultant to the Self-Represented Litigation Network and principal consultant for the network's State Justice Institute-funded study of remote delivery of services to self-represented litigants. Ooh, that was a long sentence. In 2017, he received the Ernest G. Friesen Award for Excellence from the Justice Management Institute. The award is in recognition of his vision, leadership, and sustained commitment to the achievement of excellence in the administration of justice. So everyone, please join me in welcoming John Greacen.
Before we begin, I want to test the mic. This way or this way? The latter. Yeah, I hear it better too. Thank you all for inviting me to Saskatchewan for this event. I'm really impressed with Sally. She's one of my new favorite women, and you're pushing frontiers here, and I love it. Let me tell you what I am planning to talk to you about. I want to briefly review where we are in the U.S. and Canada on the broader access to justice issues and movement. Then I want to move to the legal information, legal advice distinction, where this came from, where it is now, and its application to public libraries and public librarians, and possible approaches that SALI can take in applying these principles. I'm hoping that at the end of this talk we can have a broader discussion of some of these issues, and you can probe me to clarify anything that is left hanging. We begin with what I think has been a common history in the U.S. and Canada on the strategy for increasing access to civil justice. And I distinguish that from criminal justice because we have a recognition that everybody, at least at a serious level of crime, is entitled to a lawyer, whether they can afford it or not. But not so in civil. So we've tried to increase funding for free legal services, expand volunteer efforts by the private bar, which we call pro bono. In the U.S., we've had a long-term push to establish a constitutional right to counsel in civil cases. We call it Civil Gideon because Gideon versus Wainwright was the seminal precedent in the United States for the constitutional right to counsel in criminal cases, in felonies. And all of this is premised on the essentiality of legal representation as the way to provide access to justice. You can only get justice through having a lawyer. And that strategy has failed. And it's failed for a whole number of reasons. And life is really exciting now because we're coming up with a new strategy. It failed because people voted with their feet and started representing themselves. In the U.S., in the family arena, there are many courts where 85% of cases have at least one self-represented litigant. And the National Center for State Courts just did a study of 1 million civil cases in 20 different jurisdictions, non-family civil cases, and found that the number there is 76% of all non-family civil cases now have at least one self-represented litigant. So from the standpoint of a judge, a court administrator, a court employee, the business we are in is not the lawyer business, it's the self-represented litigant business. And as a result, we've created all kinds of court-based self-help services, many of which are affiliated with efforts by the bar to assist in the effort. In 2011, we had a major setback in the Civil Gideon movement. We were trying to expand the right to include cases of civil contempt to enforce child support payments. And the Supreme Court, it was a perfect example. A guy was put in jail for 6 months for persistent non-payment of child support without a lawyer, refused a lawyer. And the Supreme Court turned it down and said there was no such due process right under the U.S. Constitution, and cited some of these self-help services and the processes that they developed in terms of creating forms, in creating information to say that you could provide justice by using these different processes. So a judge would be required to inform a defendant in one of these civil contempt proceedings that inability to pay is a defense, and give a form to be able to present the evidence that he's not able to pay, etc. There have long been studies that showed conclusively that you did better if you had a lawyer than if you didn't have a lawyer. But there was an inherent flaw in those studies. Did anybody know what that flaw was? They simply measured the cases, counted the outcomes of the cases where there were lawyers and where there weren't lawyers. But that the ones where there weren't lawyers, where there were lawyers, were cases that had already been screened by a lawyer for merits. And the ones that did not have lawyers didn't have that screening, or perhaps they had already gone to a lawyer and the lawyer told them they didn't have a case, so they went and tried it themselves. So you're apples and oranges. And Professor Jim Greiner at the Harvard Law School said the only way we can get decent information about this process is to use a random control that we use for testing drugs. And so he had a process in the housing court in Boston in which people were randomly given the opportunity to have a free lawyer, and then measured the outcomes. And there was no difference between those people who had a lawyer and those who didn't have a lawyer. And this caused enormous consternation, as you can imagine, in the United States, until Gene Charn, also at Harvard Law School, published an article in the Yale Law Review saying we should celebrate this outcome because what it shows is that our courts are now sophisticated enough that they can provide fair outcomes for people who are coming to court without lawyers. The other reason that this strategy crumbled was the problem of scale. We have enough resources in the legal aid system in the United States to meet the needs of 20% of the people who are qualified for legal aid. So you double it, which is a preposterous effort, and you're serving 40%. You're still totally failing. So we just cannot get there from here. We push the bar to increase their pro bono efforts. Even if we got them to double it, we're still just not getting anywhere near to the goal. And the political will has never been there to dramatically increase public funding for legal aid. President Tweet has said that he is going to cut all federal funding for the Legal Services Corporation in the U.S. And so far he's been so incompetent that he can't get that accomplished. The budgets keep going through at the same amount. And he has demonstrated that he seems incapable or unwilling to learn enough about his job to actually be a danger to this funding. But we don't know. But it's an example of the lack of the public will to even maintain current level of resources. So what we're doing now is maximizing assistance in the broadest sense of the term to people, particularly those who are representing themselves, through self-help informational services, which are largely web-based, plain language forms, the document assembly processes that use an interview and produce a completed form by asking you questions, language services, ADR, assisting in the courtroom, particularly helping people to develop judgments after a court hearing. The idea of trying to get a self-represented litigant to prepare a judgment after hearing is, you might as well just go and beat your head against the wall. What you call limited scope retainers in Canada, the idea that lawyers should be providing assistance to people who are representing themselves, simplifying processes, and using non-lawyers to deliver legal services. And I'll give you some examples of those. This is the people we are serving today. And we continue to serve them. They are all online, and we serve them in line at the courthouse or at legal aid offices. So another whole approach is automation. Websites, document assembly, voice recognition software for creating transcripts, machine translation, automated reminders and prompts. So you get your message from the dentist that you have an appointment. Why don't you get the message from the court that you have a hearing? Why don't you get the message from the court that the time for filing an answer is coming up in 3 days? Remote delivery of self-help services using that dramatic new technological implement called a telephone, which reaches everybody. Video conferencing, chat, email, a whole series of ways of reaching people other than in person. Remote appearances. Why can't people show up for hearings by phone or video conference? Why can't they decide whether they want to come to court or come in or participate in another way? And then there are triaging portals. These are automated processes that use plain language. You put in your statement of what your problem is. It parses that, gives you a series of additional follow-up questions to hone into and decide whether you have a legal problem, and then connect you to the appropriate referral. In 2015, the Conference of Chief Justices, these are the Chief Justices of all 50 state Supreme Courts, and their state court administrators adopted a resolution setting the aspirational goal of 100% access to effective assistance for essential civil legal needs. Now, you see that does not say 100% lawyers for everybody, but a panoply of services that is effective for everybody. The Public Welfare Foundation in our country picked up on this and offered funding to a group of states for action planning. They didn't call it strategic planning. They said action planning to realize this 100% objective. 25 of the 50 states submitted applications for this funding. They only had money for 7. The National Center for State Courts created a document on business and technical requirements for a statewide triaging portal that laid out how this would operate. There are a number of portals today in our country, but none include all of the functionality of that requirements document. Microsoft, at the urging of the former White House, committed $1 million to make that a reality. And they chose 2 states, Alaska and Hawaii, as pilots for a full-scale triaging portal that will incorporate an AI. How many of you are familiar with that term? I see 4 or 5 hands. That's artificial intelligence. It's IBM's Watson. It's called a deep learning or self-learning neural network computer program. You give it a whole bunch of experiences. In this case, you give it a bunch of statements that people have actually used to describe their situation and what the actual legal issue is. It learns from that, and then over time, it learns more. As it has more experiences, it increases its ability to hone in on the right issue and the right referral. An example of the power of this is that it's been used in hospitals to diagnose chest x-rays for the existence of lung cancer. And so that it's shown all these x-rays and said, this one, this one, this one, this one have lung cancer. And then it creates its own program for what it's looking for in those x-rays that then correlate to either the existence or the non-existence of cancer in the patient. Today, that program does a better job of diagnosing lung cancer than a doctor. Interestingly, when you have the AI and the doctor following up, that's better than just the AI by itself. So we're not totally out of the picture, but the Microsoft project will incorporate an artificial intelligence engine into its triaging portal for diagnosing programs and making the referrals. We've also, like you have, had our American Bar Association come up with an extraordinarily good report on the future of legal services, acknowledging that the bar itself has been a major impediment to access to justice, and laying out all the ways it needs to change, just as your Canadian bar has done. I wish that the rank and file of the Bar Association had the same insight and commitment as its leadership, and I think that's the same in here. In Canada, you had Justice Cromwell's, and I know there were many other people who were participating in it, but he was the chair. 2013 Roadmap for Change, an equivalent Canadian Bar Association Reaching Equal Justice report, Canadian Judicial Council Statement of Principles on Self-Represented Litigants and Accused Persons, and then just this year, a major precedent from the Supreme Court of Canada in Pintea versus Johns, affirming a judge in applying those Canadian Justice Council Statement of Principles and endorsing the principles. In Saskatchewan, you've got your own tradition of plain language legal information from, I understand it's called PLEA, an Access to Justice Working Group following up the Cromwell Report, the Dean's Forum on Access to Justice and Dispute Resolution, and I particularly commend to you the paper that they did on the topic tonight, legal information and legal advice. The new CREATE Justice Research Center here, and a legal service task team to explore non-lawyer legal services, and SALI. That's the background. Now let's talk about this legal information, legal advice doctrine or principle. This started in 1994 when I was asked to participate in a panel at the annual meeting of the American Bar Association and to explain what this sign meant, because this sign was posted in every clerk's office in the United States. And I did legal research, and I couldn't explain the sign because there was no content to what that term meant of legal advice. And so the conundrum that was all clerks in the United States faced was that they had to abide by this principle for which there was no definition. In fact, the precedent said that we will define this on a case-by-case basis, that we will not propound any overall principles for distinguishing what is and is not legal advice. So the line clerk is supposed to do case-by-case analysis of what legal advice means. Give me a break. And that's my astonishment at this is what set me on this crusade that I'm now, 2017 minus, it's 22 years I've been trying to get this fixed for the courts. And I realize this all arose in the context of court staff. What can court staff do to help people? And what has happened is that most of the states have come up with a set of guidelines, not just adoption of a distinction, but of detailed guidelines. You can do this, you cannot do this. You can do this, you cannot do this. And I'll give you a bunch of examples of that. But it all grew out of some imperatives that courts have to be able to give information to users about how the process works. Remember, our business is dealing with self-represented litigants. The two-lawyer case is an aberration today in my country. So how can we function if we cannot help self-represented litigants to get through the process? We cannot deliver justice. But in a court environment, we have this overwhelming imperative of impartiality, neutrality between the parties. So no court staff person can take on the righteousness of a particular party's cause and specifically assist that person in achieving that person's ends. To do that violates the whole notion of a neutral court setting. So how do we deal with that? Where can we draw a line between assisting people and not taking their side? And that's where this distinction between information and advice now sits. And again, I want to say, in the context of the court-delivered services. And it's not enough just to say there's information and there's advice. You have to be given a set of coherent principles that an ordinary person can follow without having to do case-by-case constitutional interpretation on what to tell a person coming to the front counter. Traditionally, the unauthorized practice of the law divides the world into two categories: lawyers and everybody else. Lawyers can do law stuff. Nobody else can do law stuff because it's too dangerous for the public. But what has happened in our country is that we've created a third category. And we have said that court staff and some other people can do law stuff. That if Sally Schmertz on the corner were doing it, would be the unauthorized practice of law. And the most recent policy adopted in the state of Illinois is actually called a safe harbor policy, because what it says is, if you follow these rules, court staff, and it includes the staff in law libraries and court mediators, if you follow these rules, you will not be engaging in the unauthorized practice of law. And why is that? It's because of the imperative that they have to be able to give the information, and they know the stuff. Who do the lawyers call to find out how to comply with the court's requirements? the clerks. They know more than the lawyers. So what risk is there to the public of having the people who are advising the lawyers give out information to the self-represented litigants? So that's the sort of the status of this, that it may be the practice of law, but in this instance, it's the authorized practice of law by a non-lawyer. So how does it work? This is typically the structure of what court staff can and cannot do. The legal information is facts about the law and the legal process. Legal advice is advice about a course of action a client should take to further his or her own personal best interests. So, and you see where the neutrality comes in here. If court staff were doing the latter, telling this litigant what would be in his or her own personal best interests, that is, in our sense, violating the neutrality. Legal information is answering questions that start with who, what, when, where, and how, and legal advice is answering the shoulds or the whethers. Legal information is telling a litigant how to bring an issue to the attention of the court, but not whether it is wise to bring that issue before the court, or how best to present it, or to predict how the judge is likely to decide the matter. Even though you know exactly what the judge is going to do. He's done it 999 times out of 1,000. But we still don't ever do that. We don't say what the judge is going to do. A lawyer does, but we don't in the courts. We inform a litigant of the options and the steps needed to carry out the options, but we don't suggest which option a litigant should pursue. Legal advice is counseling. Lawyers always asking, what should this client do? Legal information is educating. And the question is, what does this litigant need to know in order to decide what to do? And the kinds of some courts require people to sign disclaimers that often include these characteristics. I'm not your lawyer. I'm going to give the same help to the person on the other side of the case. And I'm not covered by the lawyer-client privilege. You're not covered by the lawyer-client privilege. Now, in the courts, we certainly hold stuff confidential, but we could be subpoenaed, and we would have no privilege, no court clerk privilege of privileged communication. We've also, over time, realized what I call the website rule, that whatever is on an official website or a website linked to an official website is information. So that's a safe harbor. That information has been vetted, that is sort of universally applicable, and you can always give that information. You can always reference somebody to it. But when I'm doing this training, I always say, don't just pass the buck. You can't just say, go look at the website. I'm just saying you're always safe giving that information. But if, again, Susie Schmirk on the corner giving that information would, under most state UPL, be engaged in the unauthorized practice of law. Now, this stuff The UPL today is in enormous turmoil, and it's largely driven by LegalZoom, Rocket Lawyer, AVO, the commercial law providers in the United States. And everywhere they go, they are sued by the Bar Association, charged with UPL, and the Bar Associations always lose. In the end, they end up settling in some way by having a guarantee that a lawyer licensed in Georgia actually went over the stuff that was on the site, something like that. So they realize that this is the whole unauthorized practice of law environment is in a disruptive state at this point. But let me give you some examples of the actual, you can do this, you can't do that, state guidelines. You can explain court rules and procedures. You can't suggest which of several available procedures a litigant should follow. You can provide information about past rulings. You can't predict what the court will do in the future. You can provide cites to or copies of statutes, rules, and ordinance. You can't provide an analysis or an interpretation based on the specific facts of a litigant's case. You can explain what records are kept. You can provide public information. You can't provide confidential information. You can explain how or where to file a complaint concerning a judge, court employee, or private attorney, but you can't say, Jesus, if that happened to me, I would file a complaint against that judge. He keeps doing that to people. It's time somebody caught him up short. You can provide general referrals to other offices, but you cannot refer to a particular lawyer. I'm sure that's are there court people here? People who work in the court frontline staff? I'm just interested to make sure that that is a principle that is followed in the Canadian courts. It's a very basic ethical principle in our courts that it would be a very improper favoritism for a court to ever steer somebody toward a particular lawyer. You can provide forms and instructions and record on the forms information provided by the litigant. Now, there are many places that don't have the resources to do that, so they wouldn't allow their staff to do it unless it's a handicap situation where they're required by law. You can check a court user's papers for completeness and inform the person of specific problems identified and how to fix them, but you can't fix them. And you can't say you need to add these words. This is an example of the rule in Minnesota, which says what specifically court staff is authorized to do, including calculating the child support guidelines, preparing court orders, and here are some examples from California where staff are specifically authorized to explain and clarify court orders. They recognize that judges don't speak English on their orders. Somebody has to be able to translate it into English. Specifically authorized to assess the status of a litigant's case and provide directions concerning court requirements and procedural next steps. But court staff must provide the same assistance at the same level of service to both sides of all types of cases served. I was just in a conference with the new head of the Maricopa County, that's Phoenix, Arizona, Self-Help Center, which has 27 full-time staff. And she tells her staff, you can answer all but 2 questions. Is this right? Meaning, did what I put in this document, did I put the right stuff in this document, and what should I do? So in my training in Nova Scotia and New Brunswick, I would continually make this point, that under these guidelines, what you can do as a frontline staff person is this. What you can't do is this. And people can ask a question that is calling for legal advice. You don't have to say, you're asking for legal advice, I can't give it. What you do is you give information in response. In fact, you should never even use the phrase legal advice. And so, librarians, as you're thinking forward into this, when you're asked a question, give the information you can. Don't get in a fight with somebody over whether they're asking an improper question. What we often hear in our country is, who do you think is paying your salary? And you won't answer my question. And you're saying I'm asking legal advice. I'm not asking legal advice. I just want you to help me. Now, we have one flagrant non-complying jurisdiction in the United States. In the state of Maryland allows lawyers employed by the court to give legal advice to both sides of a case. And you have the same principle in Canada that we have under ABA Model Rule 6.5 that is designed to allow lawyers who are doing a court-based clinic or nonprofit clinic to avoid doing a conflicts check. If they know of a conflict, they can't give help, but they don't have to find out whether they are actually conflicted. So they use that as the basis for saying that they are giving short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation. And then they go to great lengths to avoid ever knowing about a conflict. So if two parties come out of a courtroom together, go into the clerk's office or the self-help center, they will say, you have to go away and come back separately because we cannot avoid recognizing that you guys are on opposite sides of a case. And this is generally true in all of our self-help services in the United States, that we do everything in our power to maintain the anonymity of people who are seeking information. So even if we, in one of these remote service jurisdictions where we're giving information over the phone, we'll take down an email address in order to send follow-up written information, but then we'll immediately destroy the email address. So we have nothing that identifies that person. So if a lawyer should come looking for a witness that she had at an earlier time said so-and-so, say, I have no idea what you're talking about. I have no recollection. And we also recognize that merely having consistent guidelines by themselves is not enough. People have to know the stuff. So we have to give them procedure manuals and training so that we are certain that our own staff are giving this consistent information and that we're giving correct information. And the most important thing is to always empower them to say, I don't know. That is always an appropriate response. And then we have standard handouts on standard problems. The most pernicious one is the service of process. how do you explain all the different ways to serve process? If you just talk to people about that, it just goes right over the head. So you have to talk to them and then hand out a piece of paper that lays it out that they can rely on. So that is the context in which this developed, the court context. And as I said, in a number of states, it now explicitly applies to law librarians, but none of the American guidelines have been made applicable to public librarians. So in our country, they're not covered in this middle ground of it may be practice of law, but it's authorized. They're hanging out. But the concept has taken on a life of its own, and it's used in a number of places beyond the courthouse. For instance, in legal aid offices, if they're simply giving information to help a self-represented litigant or a person represent himself, that can be done by a non-lawyer under this notion. But if they're giving detailed advice of how to best pursue the case, then that is done by a lawyer. But I've realized that for this conference, you need to have some other examples of, in our country, how librarians and other people have been involved in access processes. In California, they set up a statewide chat system that was staffed by librarians. And they would each sign up for a certain time during the day and man the chat system, answering questions. In Illinois, for a long time, the courts did nothing to help unrepresented people. But the legal aid programs got together and put together a marvelous website called the Illinois Legal Aid Online, which they have now redone twice. And the current version has, I think it's 1/3 of the content of the earlier versions, because no matter how much we lawyers try to write in English, we don't. So it was redone totally by plain language experts. The Chicago Bar Foundation then went out to every court in the state and built a little website for that court and provided computers to the local public library. And the website refers people to the local library to get access to the ILEO website. So that is how legal assistance was provided in Illinois. That was the only way that it was provided for self-represented litigants, and the local public librarians were the key link in that. There are, in many courts, the public libraries are included as part of a web of access services, including being the default provider of access to computers and printers, helping members of the public to use online resources, helping to prepare forms, helping with language and literacy issues. And this is particularly true where the services are delivered remotely, not face-to-face, where it is obvious to the service provider that it's not getting through. This person needs more help. Well, go to the library and have them call me, and then we'll work through it together. So it's the hands-on, the face-to-face assistance that a remotely delivered service can't provide. There's also an expectation that librarians and social service workers will guide members of the public through a triaging portal. There are a lot of people who will not be able to directly use an online tool like the AI-assisted one that Microsoft is building. So it's always anticipated that other people can enter information on your behalf if you're not able to do it. There are statewide remote service delivery systems in Alaska, Maryland, Minnesota, and Utah. In Arkansas, the state Supreme Court Law Library has been proposed to be the hub of self-help service delivery network throughout the state. In Massachusetts, they did this marvelous survey of social service agencies and social workers and said, do you help people with their legal issues? Oh, no, we don't do that. Well, do you fill out forms for them to file in court? Oh, sure. Do you ever go to court to help them? Oh, yeah, a lot of time. And, well, what do you need? And what they came up with was a process where there is a legal aid lawyer who is available to answer questions posed by the social workers. Washington has this very elaborate limited license legal practitioner program called LLP. You may have heard of it. It is to license non-lawyers to practice law. But they are not allowed to go into court. They're not allowed to write deeds. There are many restrictions on it. And it's a very elaborate process where they have to get training in a subject matter, training in the law itself, and a whole course on ethics, and pass 3 basic bar exams to become licensed. There are 17 of them in Washington State after this has been in process for 4 or 5 years. So it's a scale problem. They also have not come up with a good business model for these people to make a living, so most of them are ending up working for law firms. And in New York, the Navigator program in Housing Court uses non-lawyers, trains them up. A number of them are just volunteer college students, and they have forms available that list all of the available defenses to eviction and debt collection cases, and then they let the navigators help people to figure out how they apply to their case. There are federally funded Justice Corps programs where college students are assisting with court self-help centers. The ABA has adopted a model where a state will set up a website where you can you can email a question, and their lawyers will get together on Saturday afternoon and answer the questions. Do you have medical legal partnerships in Canada where lawyers go into the hospitals and train the doctors and the nurses and the administrators on the legal issues that are coming up in medical situations in terms of medical powers of attorney, conservatorships, the standard kinds of things where people in hospitals need legal help. There's a wonderful program in Northern California where they're using video conferencing to provide workshops in many counties at the same time. And there are existing triage portals not using an artificial intelligence engine, but doing the automated analysis of what is the legal issue and connecting to a